Good morning. Everybody must be froze up somewhere. Wendell got here on time nearly today. Y'all keep yours, he ain't gonna keep his. Y'all bow with me. Gracious Heavenly Father, again, here we are, asking you to forgive us of our sins, to say thank you for the wonderful blessings, to ask us to remember that we live in Georgia, and it ain't supposed to be this cold, Lord. Guide us and direct us. Keep us in your arms. Let us do things pleasing to you. In Jesus' name I pray. Amen. Well, good morning. Mr. Battles.
Thank you, Mr. Chairman. I come to you, and it is on your list and under structured, House Bill 202. Just to kind of preface this, is last year you passed out of this body 295, which was in fact a piece of legislation that had a comprehensive revision of provisions concerning the ad valorem tax, the assessments, the appeal process, and the Board of Equalization. There was an amendment, as you recall, because most of them were here. We had an amendment that was added a portion to that bill or that legislation as to add compensation for the clerks of the court. When it got to the Senate, that was stripped out, and on day 40, it met that terrible death of not being passed. Over the summer, there has been the work between the House and the Senate, along with the tax commissioners, the clerks of Superior Court. That has been remedied, and that has been done by now setting aside an appeal administrator that would be in the clerk's office, and their salary would be underneath a new line item in their budget. And so, as I said, this was passed. The only change is that we now have a new appeal process, and it was taking care of that concern that the Senate had. And I'd ask for your consent.
We got questions? Thank you. Mr. Martin.
Thank you, Mr. Chairman, members of the committee. This bill is House Bill 164 under modified open rule. It's the sixth bill down on your front page sheet, LC 335916S. What this bill seeks to do is actually extend by 2 years a policy that Chairman Dixon did a few years ago to allow the Professional Standards Commission to work on the governor's initiative for new standards for teachers, professional development in the state of Georgia. That was set, those standards were set to go in place before July 1st of 2015, and after that time there would be new standards that teachers have to meet. Those standards are not yet ready, and they have asked us to extend that date to July 1st, 2017, and as such, to give the teachers a waiver of their PLU requirements until that is done June 30th, 2017. This has been discussed in education. Chairman Dixon could comment further. He's very knowledgeable on the original intent of it. I asked the chair's concurrence to move this onto the floor so that we could let the teachers know, since the date is so short, July of this year.
Any questions? Any comments, Mr. Dixon?
This is a good bill. it will not keep a local system from requiring a teacher to take some kind of remedial course. It's the annual certification requirement that's being waived.
Thank you, Mr. Martin.
Thank you.
Mr. Tanner.
Thank you, Mr. Chairman. I have two bills, if I could bring them both to your attention. One is the third one under Modified Structured Rule, HB 95. This bill would allow the State Depository Board to set up rules and regulations to split off the local investment pool money from the state investments. This is at the request of the state treasurer. Those current funds are currently commingled. ACCG and GMA are both fine with this legislation. That's HB 95, Mr. Chairman.
Questions on 95? Next one.
Mr. Chairman, under structure rules, second one down, HB 63. This is the Georgia Employer GED Tax Credit Act of 2015. This is revamping a current tax credit in the code that's not functioning, and this came through Ways and Means with strong support. It would allow businesses the opportunity to be involved with employees getting GEDs and employers being able to receive a tax credit. Has strong support from the business community and strong support from the Ways and Means Committee, Mr. Chairman.
Mr. J. Powell, any comment? Thank you.
Thank you, sir.
Mr. Turner.
Thank you, Mr. Chairman, members of the committee. I bring before you HB 73, which is the second one down under Modified Structured Rule. It would, this was a bill that passed out of the House unanimously last year, 164-0, ended up in the Senate Rules Committee on day 39 and did not get out onto the floor of the Senate. But I think it's important that we tackle it again because it would allow for enabling legislation at the local level to establish durational residence requirements, or in other words, you can set up a residence requirement of up to 1 year for your county commissioners or local elections to live in a post or district within that jurisdiction.
Any questions? Thank you.
Thank you.
Mr. Wilkerson.
Thank you, Mr. Chairman, members of the committee. Today I come to you to ask for House Bill 177, which is under Modified Open Rule. This is the defects reporting bill that we passed out of the House last year unanimously, and it came out of committee unanimously again this year. It would basically close the reporting loop and require that defects give certain reports back to our school counselors whenever there's suspected child abuse. It is supported by the School Counselors Association as well as it is also supported by DFACS. And I take any questions and I ask for your favorable consideration.
No questions. Thank you.
Thank you.
Wait a second. I'm sorry. Yeah, you do. Mr. Leader.
Sorry about that.
I'm curious. It mandates that DFACS make a report within a period of time in writing. Why are they supporting having to pass a law to make them do what they ought to be doing anyway, if that's the case?
That's a good question. Sometimes it was something that they're getting better at, but they feel that putting it into statute would be a good thing. It would also, we have mandatory reporting on the front end where you have to report up to the state, but currently there's no requirement that they report back down in a timely fashion. So they feel that this would close any potential loops. Currently, they are okay with it, doing it, but there's no guarantee in the future that future, folks might be as comfortable doing it or may not do it as timely fashion. So it really just is, as we're looking at a child and making sure that front line is getting the information they need to protect our children, they feel it would be good to put it into statute.
No more questions. Thank you. Am I supposed to swear you in, Mr. Castard, or is...
Thank you, Mr. Chairman. Members of the committee, I promise I'll be honest with you here this morning under oath.
You'll be the first one.
This is an economic development bill, came through your Economic Development Committee unanimously. Deals with the deepening of the ports of Savannah. It amends the Georgia Ports Authority Act to clarify that it does have the authority to provide an indemnification in exchange for receiving the federal funds needed to start that deepening project. It's a $705 million project. That's $266 million in state funds, $439 million in federal funds. It's a three-party agreement between the Georgia Ports Authority, the Georgia Department of Transportation, and the United States Corps of Engineers. The Corps requires an indemnification clause in that partnership agreement before they'll start the project. We believe that our current Georgia Ports Authority law allows this already because it has language here you'll see that allows it to comply with whatever terms and conditions imposed by the federal government. This is one of the terms and conditions, that there be an indemnification clause. So it just clarifies that, and it was necessary in order to begin that project.
Any questions? Thank you. Vice
Thank you, Mr.
Secretary.
Chairman.
Who? You gonna carry it? Thank you.
Thank you.
Mr. Duncan.
Thank you, Mr. Chairman. You will find House Bill 227 under the structured rules section. And this bill was brought forward by the Department of Revenue. Very simple bill. The toughest part about it is the pronunciation of the word programmable. We're striking the words programmable thermostat. Currently, the federal definition for the EPA does not include programmable thermostat, but in Georgia law it does as far as the Energy Star qualified products. So it's creating some confusion at the retail level as to when they should charge sales tax on the sales tax holiday or not. I'd answer any questions.
Thank you. So by striking it, they will no longer be eligible to be exempt from sales tax. Is that correct?
Programmable, and currently they're not, but it's just a confusion because I believe it's at the federal definition is what sets up the Energy Star qualified product.
Okay, thank you.
So some retailers are collecting it in error currently, are honoring the discount currently.
Right. So it will clarify that they are to collect sales tax on programmable thermostats.
That's correct.
Okay,
thank you.
No more questions. Thank you. Mr. Harrell.
Thank you. Thank you, Mr. Chairman, members of the committee. House Bill 49, the first one under structured rule. As with several of the earlier bills, this is a bill that passed the House last year unanimously, was included in a larger bill in the Senate that actually passed the Senate but did not get out of conference. It is a permissive bill that would allow taxing jurisdictions to make a decision to offer property tax bills electronically. And if they did, then the taxpayer would have the option to receive it that way. In my county, which is a fairly large county, they estimate they could save $140,000 a year in billing costs by those that voluntarily participate.
Questions? No questions. Thank you.
Thank you.
Rocky Raccoon, you're up.
Thank you, sir. I come before you again with HB 160, Modified Open Rule. The DNR came up to me this year and asked if I would carry this bill that would pretty much eliminate a line from the northern zones of 60 to where they feel that the population of raccoons are pretty much overpopulated, and it allows with legal intent of trapping raccoons, which now it is illegal to trap, and they must write you a ticket. They do not want to write you a ticket. And for safety reasons, that's one of the reasons they also wanted passed.
So just to be clear, trapping is totally legal in the northern zone. And if a raccoon happens to wander in there to the trap, the DNR is in a position where that they have, by law, they should be writing a ticket, even though the practice of trapping is legal. And I don't know much about trapping. We don't do much of that in Peachtree City. but it's impossible to trap in a way that's going to filter out the raccoons and trap the animals that are legal to trap, correct?
Yes, that's pretty much true. You can trap beavers, rats, mice, different other critters, but raccoons, it's illegal in the northern zone.
Right. Thank you.
Mr. Powell.
Did I understand from one of your previous 5 appearances before this committee that you said that there were trappers in this house that had told you that they did not realize that it was illegal to trap in the northern zone?
Yes, sir.
How many trappers do we have in this house?
Probably, I know of 8 different ones that have come up to me and said that they had no idea that was a law they were breaking.
That's why they stay in South Georgia, too. Thank you, Mr. Donahue.
Thank you.
Mr. Teasley.
Thank you, Mr. Chairman, members of the committee. Come before you and ask for, under modified open rule, House Bill 126, which would make it is technically illegal to have a GPS mounted to your windshield due to an oversight in code, the code that was written 30 years ago that didn't anticipate GPS devices. So this makes a specific exclusion primarily for passengers to be able to mount a GPS device to their windshield.
Any questions? No questions. Thank you.
Thank you.
Mr. Jacobs.
Thank you, Mr. Chairman. Under the structured rule, House Bill 215, this bill effectuates the recommendation of a bipartisan task force that was convened between the legislative sessions in DeKalb County to solve a number of issues, but this deals specifically with the homestead option sales tax. Presently, DeKalb is one of 2 counties that has the homestead option sales tax, and this bill would apply only to DeKalb County. I want to stress that. The present homestead option sales tax is divided 80% for homestead property tax relief and 20% for infrastructure funding. And that infrastructure funding is divvied up in such a way that the cities get a significantly larger portion than the unincorporated area. The recommendation of the task force is that we go to 100% for property tax relief. And I'm sorry, the reason that the cities get an extra share of the 20% is because the homeowners in the cities don't get a benefit out of the 80% for city property taxes, the way that the current host law is structured. So we would go to 100% for homestead property tax relief and apply that 100% in exactly the same way to citizens who live in the cities and in the unincorporated areas, so everybody gets exactly the same homestead property tax benefit. It also would enable DeKalb County to go to an 1/8 penny to levy a SPLOST. That SPLOST would then become the source of infrastructure funding for the county and for the municipalities, and it would be divvied up on a per capita basis. Again, I'm actually bringing you a bill, Mr. Chairman, that has the support of, I believe, all of the members of the DeKalb delegation on both sides of the aisle.
Mr. Hamilton.
The sea has parted.
Thank you, Mr. Chairman. Since you brought up that last part about the support of all of DeKalb County, I have to ask you, do you plan on bringing any bills forward this year that do not apply only to DeKalb County?
I do. In fact, I have one that just came out of judiciary yesterday that I'll be here asking for tomorrow.
Anyone else? Thank you. No. Mr. Dixon.
We can adjust
now do it. Now do it.
Would request House Bill 100 to adjust the age that a child must be when they enter kindergarten.
Any questions, Mr. Dixon? Mr. Hamilton.
Thank you, Mr. Chairman. I have three bills: modified open House Bill 117, which is a Department of Labor bill under modified structure, House Bill 121, which is a Secretary of State's bill, and then House Bill 194, which is the early voting bill.
Anybody got any questions on any of the three bills Mr. Hamilton just had? Okay. Mr. Stevens.
Mr. Chairman, we typically don't do Senate bills until after we've finished all the House bills, but in this particular case, it's time sensitive, and with fish spawning and mitigation and all that stuff, I would request that we move this one as soon as we can to get it on the governor's desk. Senate Bill 5.
Okay. Ms. Dempsey.
Is it on now? Yes, Mr. Chairman. I'd like to ask again for House Bill 198 to incorporate annual suicide prevention education training for certified school personnel in the elementary and secondary programs in our state, and allow that during their in-service time.
Who supplies these, the books or pamphlets or whatever? Who supplies that?
There's a lot of local control under this bill. If you'll look, it is decided by each individual system. Many are online and are free. They can also bring in speakers if they wish. Each system will work with the Department of Education from a list that the department will decide in coordination with the Department of Behavioral Health and Disabilities to approve those. But there is a lot of local options. And like I say, this newest one, the Jason Flatt Foundation, will be providing completely free of charge.
So that comes under who pays the next question? Nobody?
I'm so sorry. Nobody, right, yes, sir. If they choose that one, but if a school system individually decides to have something that would cost, then that school system would have to come up with the funding, not the state.
Okay. Mr. Leader.
Thank you, Mr. Chairman. I just wanted to put my name by Senate Bill 5. Like Chairman Stevens said, we generally don't act on those, but it is my researched understanding that that's one of the last obstacles before we actually start digging in that wonderful Savannah port, where we can see the fruition of our state's huge investment down there, and it is time sensitive. So I would urge this committee to take up that bill as soon as possible.
Mr. Willard, do you want to take the stand, or you want to do it from you?
I'll go up to the stand. It may take a few minutes to answer some questions.
While he's going up there, I've got Mr. Knight over here.
Thank you, Mr. Chairman. If you're tired of hearing from CPAs, and I'm one, and I'm tired of hearing from them, we've got to get this IRC update bill through. As you know, every year the federal government has changes to the code, especially around the items of depreciation. And as such, Georgia must, after they adopt those new laws, we've got to come back in and adopt them or make the changes. And this is especially important with the Section 179 depreciation that's out there. If we do nothing and we let it stand, Georgia will go back down to $25,000. This bill returns it to what we've previously done, which is a limit of $250,000. Very important. I'll also note that the urgency is we've got to get this bill over to the Senate, to the governor to be passed, that it's passed into law, and all of the tax software companies can update the tax software so that people can file their tax returns right now. So there's a bit of urgency, and I would also ask that if we're going to recognize the Senate bills over here, this is one that I hope that the Senate will honor when it goes over to the Senate side. This is very important to all of the taxpayers of the state of Georgia.
Mr. Willard.
Thank you, Mr. Chairman. In your folder is House Bill 59, and I think this may be one of the more important things we're going to do this year if this bill does pass, and this is reinstating what we believe was already the rights that citizens of our state had when they were aggrieved by conduct of a state agency by doing something that may be either unlawful or unconstitutional, acting outside the scope of what would be their authority. And in the past, there was a right to have actions brought in the courts to seek an injunction against that unlawful conduct or wrongful conduct, and also to have the court make an interpretation of either statute or rules or regulations. This past February, the Supreme Court, in a decision known as the Sustainable Coast case, our state Supreme Court, by unanimous decision, said no, because of the constitutional provision that we have that was enacted back in 1973, we have taken the common law of sovereign immunity and embedded that in our Constitution, and that constitutional provision said that only the General Assembly would have the authority to remove sovereign immunity from a governmental body. We have done that in the past on several occasions, and what I think of in recent times, the Tort Claims Act of the state, as well as removing the shield that was there for automobiles owned by government, where back in, I think, 2002 or 3, we recognized that any car on any vehicle on the road should have insurance, even governmental bodies' ownership of vehicles. So, with that background, the Supreme Court said unless the General Assembly removes the sovereign immunity for governmental bodies to have the courts address injunctive relief or declaratory judgment, there was not a right for an aggrieved citizen of our state to do so. With that decision, it has stopped the ability of our citizens to have the right to have the courts examine conduct by a governmental body on those bases. And this provision is to put back in place that right, which we felt the citizens have, because the General Assembly is saying that is something that we want our citizens to have the ability to do. And I would encourage the support of House Bill 59, Mr. Chairman. I'd be glad to answer any questions.
I'm first.
Mm-hmm. Mr. Smith, wait a second, you got it.
You got some questions.
All right.
Mr. Chairman, I talked to 3 different attorneys yesterday, and not being an attorney, probably not near smart enough to be one. Each one of those attorneys said this is going to open us up for lawsuits on the county level, state level, department head level, and the state and all. And they're very concerned that
yes,
it's just going to open up Pandora's box as far as lawsuits.
Thank you. That's a good point. And I'll respond by saying prior to the February decision, that right previously existed. Now with that decision, what is the only means that we have to address the stopping of what may be an unconstitutional, unlawful action by a governmental body is to sue individually those persons who are doing it or directing it. And I don't think, I've talked to different department heads and directors and commissioners, and I explain this to them, because the only people who have come to me with doubts or questions about this, frankly, has been those who are in those type positions, either directors of a department or commissioners of a department, or in one case, I've talked to your mayor down in Columbus. And I understand their concern. The right has previously existed. We're putting back in place what we believe to be the right prior to that February decision. And I don't think these people want to be sued individually. I think if there's something to be done, let them be brought before the court in their official capacity, not as an individual. Thank you.
Okay, Mr. Roberts.
Mr. Roberts.
Thank you, Mr. Chairman. Mr. Chairman, is this retroactive? Is there?
No, sir. It become effective upon the signature of the governor. So anything that's pending now still has the effect of the Sustainable Coast decision hanging over it.
Okay. Thank you.
Mr. Fleming.
Thank you, Mr. Chairman. Mr. Chairman, I want to make sure I understand what you're telling us. Citizens have always had the right to go into court before a judge and say, Your Honor, this local government is doing something wrong, unconstitutional. Supreme Court said, you know what, Georgia law's got a hole in it, you really can't do that. So all we're doing is reinstating the right for citizens to go before local government and allow a judge to stop them from doing something they're not supposed to do. Is that right?
That's correct. If they're doing something wrong, there should be a right for, as we define here the term, you use the term aggrieved person, having that ability to go into court and say, Judge, they're doing something to me that's improper.
Jay, you got more? No, ma'am. Anyone else? Thank you.
Thank you, Mr. Chairman.
All right, we're going to set it. This is for tomorrow, Thursday. Under structured rule, HB 292. Any opposed? Motion carries. Under structured rule, HB 227. Any opposition? It's on. Under modified structure, SB 5. Any opposition? It's on. Modified open, HB 164. Any opposition? Modified open, HB 117. Any opposition? Modified open, HB 100. Any opposition? It's on. Under modified structure, HB 95. Any opposition? Under modified open, HB 198. Do I hear move? Any opposition? That's it.